We now call 25 CR 329, the state of Texas versus Charles Daryl Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Okay, everybody?
Yeah.
Earlier, you pleaded guilty to...
All right, pause right here. This case might sound routine at first, but don't let the casual tone fool you. A guilty plea is already on the table, which means today isn't about whether he did it, it's about how hard the hammer is going to fall. And trust me, by the end of this hearing, everything changes.
This indictment, which alleges the second-degree felony of burglary of a habitation, a pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, State?
None from the state, Your Honor.
None from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked.
This is a critical moment. The judge just laid out the full sentencing menu, anywhere from probation to 10 years in prison in Texas. A second-degree felony like burglary of a habitation carries serious weight. But notice this. The court still has discretion, and discretion is where things can swing wildly based on history, credibility, and accountability.
Back in 2002, then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 30 days in jail. These are misdemeanors. Possession of drugs, 30 days of marijuana. Another in 2012. There were 2 of those in different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So
It's true.
That's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana.
Yes, sir.
And then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances.
Yes, sir.
This is where the courtroom temperature starts rising. Prior convictions aren't just numbers. They're patterns. Multiple drug offenses, prior probation revocations. Judges don't see this as old history. They see it as a track record. And once the word pattern enters the room, leniency quietly exits.
All right. Go ahead.
Your Honor,
You may go forward.
Thank you.
If you wish.
yes, please, Your Honor. We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight as the court term probation. Looking back at his criminal history, as you see,
His time. The credit, please. Thank you. Go ahead.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who, I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she said she asked the court to order the defendant not to have any contact with her in any way. If you were placing him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years, versus if you send him to prison, we all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from his par at that point. I mean, she can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation, and if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation. You could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get him evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not, the conviction was in 2012. So I think that probation is probably the best in a case like this. That's all I have to stop.
And then the other side. Let me ask you, before we go forward here.
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No. Okay.
Yeah. I know that's
All right. All right. Go ahead, State.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out, and she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this, and he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as a witness about
Okay.
that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct?
Right.
Okay. You did go in the house uninvited, correct?
We went into the house.
Hold on. Hold on.
This is a smart defense argument. Probation keeps the court in control, protects the victim, and offers treatment instead of warehousing, but here's the tension. Probation only works if the judge believes the defendant is honest, accountable, and realistic, and that belief is about to be tested hard.
Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above date, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry. He forced his way is a violent act. Okay, let's correct the record. You weren't invited in. It says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there. They went in. It wasn't a situation.
He's saying the police are wrong in this report.
Well, the
Is that what he
police-
said? Well, no, let's come on.
Well,
Let's get
let's-
it straight.
let's get straight.
Is this, nobody objected to this. That's what makes me
Because that's-
unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in.
Your Honor.
Is this wrong or not?
That's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
Okay,
his
all
position
right,
is
but
different.
that's what, well,
It's not, we can't
but
object to what the police
you need
say.
to- If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me.
Okay.
I mean, I do read this, but sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, Your Honor,
Go
we
forward.
had the trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to get a question, is that he did go in uninvited, kind of forced way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they don't understand the difference between breaking into and going out without consent. I think
Facts
that's
are
what
the facts.
The facts are
That's
facts.
all I want. It's facts.
Facts are facts, but I think when you ask, did you break in, he's going to say no, because most non-attorneys deal with this don't consider just going in without
I've
permission.
done this for 40 years. I know what you're saying.
Okay, all right, good. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Right. Well, I think the facts are, like I said, the facts are the
I'm a
facts.
fact finder.
He went in without permission, and some bad things happened. I think there's no question about that. Okay. The question is in his report. I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him when asking the defendant if he broke in.
And this is the moment it slips away: denial, minimization, no intent. When someone downplays strangulation, one of the most lethal forms of domestic violence. It's a massive credibility red flag. Judges look for ownership, not excuses. And right now, the court is seeing someone who still doesn't get it.